conduct blood alcohol testing when it's obtained the defendant's blood pursuant to a search warrant that authorized the blood draw, but is silent about whether the state can conduct blood alcohol testing after the blood draw? The answer is yes, and the trial court's contrary ruling has three main problems. It's inconsistent with settled constitutional principles, it rests on a flawed interpretation of Skinner and Scarborough, and it conflicts with the overwhelming consensus of courts in other jurisdictions that have addressed this issue. So to begin with the constitutional principles, we know that the Fourth Amendment in Article 1, Section 7 of the Tennessee Constitution prohibits unreasonable searches and seizures. We also know from the court's precedents that a blood draw is both a search and a seizure. Now, when a search or a seizure is done pursuant to a warrant, that search is presumptively reasonable. That's exactly what happened here. Police obtained a search warrant for the blood draw, which was executed at Williamson Medical Center. It was supported by probable cause that the defendant had been driving under the influence of alcohol, and that search was completed upon the blood draw being performed. So at that point, the state was free to examine or test that evidence without further constitutional justification. It wasn't required to obtain another search warrant to test the blood. If it had done so, it would simply be reciting the same facts, establishing probable cause for the blood draw. You would basically just copy and paste the affidavit in support of the search warrant application. There's no point to doing that. So how did this case go wrong? The defendant argued, and the trial court ultimately ruled, that the blood alcohol testing was a separate search for constitutional purposes, separate from the blood draw. And the reason the defendant argued this is that in both Skinner and Scarborough, there's some language talking about the different privacy interests that are implicated during the course of a blood draw. So during the blood draw itself, there's a physical intrusion into your skin, and that's one type of invasion of privacy. But then the blood alcohol testing obviously implicates different privacy interests. There's the physiological data that's contained within your blood. And the state acknowledges that's very important medical information that can reveal a lot of information about a person. But here, the blood alcohol testing was not a separate search because once the search warrant for the blood draw has been executed, that extinguishes the defendant's expectation of privacy, at least with respect to the blood alcohol concentration of their blood. So at the point that we've seized the blood pursuant to a search warrant, you no longer have that reasonable expectation of privacy. And that's the way the courts have defined what a search is. A police activity isn't a search if it's not infringing upon some privacy interest. So, and the state's brief cites several cases from this court that's recognized this principle in other contexts where you have lawful seizure of evidence under the plain view exception or an inventory search or something like that, and there's a reduced or an eliminated expectation of privacy. I'm not going to go through all those cases, but I do want to focus the court's attention on the United States Supreme Court decision in Schmerber versus California. I think this does a lot of work for us here. In Schmerber, the court held over 50 years ago that exigent circumstances sometimes can justify a warrantless blood draw and blood alcohol testing. Now, obviously, the exigency ceases after your blood is taken, right? So you could, in theory, rely on the exigent circumstances exception to draw the blood and then obtain a search warrant to do the blood alcohol testing. Nothing in Schmerber indicates that the state's required to jump through those hoops. It treats the blood draw and the blood alcohol testing as one event for constitutional purposes. And several courts have honed in on this and rejected the defendant's argument for precisely this reason. In over 50 years, that I haven't been able to find a court that has held, without getting reversed, that the state would be required to obtain a second search warrant.
So what was the trial court's, basis for suppressing? Can you give me what the trial court in this case was kind of thinking? You've given us tons of law. I'm assuming that state gave the trial court the same. So what's the state's position on why this trial court said, hey, no, you violated this person's constitutional rights here?
Yes, Your Honor.
contrary to all that law.
Yes, Your Honor. I do think it was well briefed in the trial court. We had a pretty extensive response to the suppression motion, which doesn't always happen, but in this case it was there, and the trial court simply did not engage with many of the persuasive authorities from other jurisdictions. There was no discussion of other jurisdictions and how they've treated the issue. The best I could tell, it was just this reliance on Skinner and Scarborough, these isolated sentences that describe the different privacy interests that are at issue with the blood testing and the blood draw. And I think that's where what led the trial court astray. Because if you have the privacy interests, the thinking is then it must be a separate search. But that just doesn't take into account that when you've executed a warrant that extinguishes the privacy interest and it no longer exists. And that's why we've discussed the Skinner and Scarborough case at length in our brief to explain what was going on in those cases. In neither one of those cases did you actually have a search warrant. So the court is, in the Skinner case, dealing with federal regulations requiring warrantless blood and urine testing after certain major train accidents to make sure that those that were involved were not under the influence of a controlled substance. But that was a warrantless type of a search, and it was actually upheld because the court said the government's interest in public safety actually outweigh these privacy interests that we're talking about. But the discussion of the privacy interest was just more in general, talking about everything that's involved in a blood draw and the blood testing. And the same goes for Scarborough, which involved the DNA collection statute. It was a warrantless search for DNA for incarcerated felons, and the court is just generally citing Skinner for these broad propositions about your privacy interest and the contents of your blood. But because neither one of those cases involved a warrant, they don't address the narrow issue here, which is when we execute a warrant for the blood, can we then examine the blood for the purpose of obtaining it? I mean, again, to require a second warrant would simply require the state to copy and paste the search warrant affidavit. And I know the defendant says, well, you don't have to get a second warrant. You could have just done the first one, in their view, properly. But we know that search warrant affidavits can be, they run the gamut in how detailed they are. A warrant could always be more precise in the way you've worded it. But the issue is not what would be most efficient. It's what does the Constitution require? And here we satisfied the Constitution by obtaining a warrant for the blood draw. And after that, we were free to examine it. Now, perhaps there's a limiting principle here, and maybe a case would arise where the state tried to conduct some other tests that didn't relate to like the alcohol concentration in the blood, and maybe the defendant would have a better argument that we're limited by the probable cause that's in the affidavit. But here we don't even have to reach that issue because all the state did was conduct a blood alcohol test, and we certainly had probable cause for the alcohol concentration in the blood. And again, just to wrap up, the defendant says we haven't cited enough authorities from other jurisdictions. We've cited 10 state court decisions, 3 federal circuit court decisions. I couldn't find in the defendant's brief, though, a single case from another jurisdiction that went the other way. I certainly haven't been able to find any, again, that weren't reversed on appeal. So we do think that the overwhelming weight of authority supports our position here. And lastly, I'll just comment on this Riley decision from the U.S. Supreme Court, which dealt with the cell phone issue. Riley is distinguishable because it involved the search incident to arrest exception to the warrant requirement. So there, the court said, yes, there was a lawful seizure of the cell phone, but you still needed to get a search warrant to look through it. But the reason it said that was because when you're seizing a phone pursuant to the search incident to arrest exception, you're only doing that to preserve officer safety and to preserve evidence. But once you've seized it, those concerns are kind of satisfied. So there's not really a justification for 2 hours later just going through the phone, scrolling and looking for things on a fishing expedition. Here it's completely different. We have probable cause for the alcohol concentration. That's what we're testing it for. If there's any analogy to a cell phone, it would be more like the state obtaining a search warrant based on probable cause that the defendant's texting his wife about committing a murder, and we get the cell phone pursuant to the search warrant, but we can't read the text messages without getting a second warrant. That wouldn't make any sense. So unless the court has further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, Mr. Groves.
Thank you.
Mr. Hubble? McKinney, okay.
Judge Campbell, Judge McMullen, Judge Wiedemeyer. My name is Robin McKinney. I represent Ritika, Arora. I would like to introduce Caroline Barano. She's a law clerk at our office. She's finished her third year at law school at Belmont. Judge, this case is very simple, and I like to be permitted to read from the exhibit of the search warrant. The police officer was to transport the suspect to a person qualified to draw blood in Williamson County, Tennessee, where you shall search for, seize, or maintain as evidence the property described in said affidavit, to wit, human blood. Period. End of story. That's all the authority that the court gave, or the magistrate gave this officer. It didn't give him the authority to send it on a SpaceX to the moon. It didn't give him the authority to send it to a private doctor to test it. It didn't give him the authority to send it to an accredited lab. There was no other direction. And once this warrant was issued this way, it became a general warrant, just to search something, just to grab something, and not any direction what to do therefore.
Not human blood?
It's a general search warrant. It's our position, it's a general search warrant, because there's no direction of what you should do with it. There's no order. And the judge, and Judge McMillan, you asked what, McMullen, I'm sorry, you asked what the court hung her hat on?
Yes, sir.
On page 6 of her order, she cited the nunnery case, and she again quoted with Judge Williams, when he was here, to condone the failure to abide by the limitation included in the search warrant, in this case, would open the door to officers failing to abide by conditions in search warrants. In other cases, it would also require courts to distinguish between the failure to abide by significant limitation and insignificant limitations. We, like this court and Bob Wilson, see no reason to embark on a ride down that slippery slope. And coincidentally, she was the same judge that suppressed the search in the nunnery case as well. So she relied on that language, the clear language from the opinion in nunnery, that this is what it is. Now, I did, for the trial court's edification, I did submit an exhibit of what a proper search warrant should look like. It was Exhibit E attached to the motion. In this one, this is the Metro Police, the Police Department here in Nashville. It goes on to say in the paragraph, you're commanded to take the blood, but it also says, after you seize it, seize the blood, and to further examine said blood for evidence of impairment, including but not limited to alcohol and or drugs as determined through a forensic toxicological examination. So in the Davidson County search warrant, they do it right. They do it right. Because they say, we're going to seize the blood. We're going to put a needle in your arm. We're going to take it out. We're going to put it in the crime tube. We're going to do the inversions. We're going to put it in the evidence box. We're going to maintain chain of custody, and we're going to take it to an accredited lab. Because in the statute, only blood samples that are done by DUI have to be done by an accredited lab, and that's one that's approved by the TBI. So there is some sort of procedure here. So we look at what's happened in Williamson County and versus happened here in other counties. And I will tell you, I practice in Middle Tennessee. It is a grab bag about what search warrants look like. You have police officers, retired police officers in Sumner County issue search warrants, but in Davidson County, everybody's a lawyer. So you've got a Pandora's box of what's going to happen. And I'm sorry I got off track of my argument because I wanted to answer your question right off the bat. So that is where she came up. And Judge, just like the nunnery case, the legislature took care of that issue about the multi-county search warrant. And then what I've been told is they've changed the search warrant requirement on these issues by the recent state legislature. I tried to find it and I couldn't find it through Westlaw about it. But Judge, this is a general search warrant. And even if you suppress and uphold the court, which I would submit you should, the DA's office still has a case of a DUI, the old common law DUI. They've got a drug charge. They've got a paraphernalia charge. They've got an accident. They've got Miss Arora was at a event at Arrington Vineyards, driving home, had a little accident, urinated on herself. If they can't convict her with that, we'll give it our go. Then they need to turn in a law license. But they appealed that, and they just don't want to set forth that they made a mistake, and these search warrants that are out there are invalid. And that is what's wrong right now, and why they're testing this is there's a few cases that we have in other counties with this is the same precision, just kind of on hold, waiting this case. And this case is not only do you have the general warrant, but this case is emboldened the law enforcement out there that they can play loosey-goosey with the law. And Monday, motion suppressed in Sumner County. The police officer got consent to tell this individual, says, well, just consent to the blood test because every case in Sumner County gets reduced to reckless driving. The motion suppressed. We had an expert ready to go, Mr. John Pellegrin of the Sumner County Bar, who was going to testify, we settled the case, who's going to testify that a reduction in Sumner County is akin to the parting of the Red Sea. So that case was resolved. We've got officers that will testify 30 times, I don't recall, in Robertson County, where Judge Wiedemeyer's old district was. And I don't recall about it. Lose the implied consent form. Play willy-nilly with this case. And we have to send a message. That's why this case is important, because we need to tell the police officers, do your job. Do your job. Just because it's a DUI case, it's just important, not more important than the last murder case we saw. Because the DUI affects truck drivers, nurses, a whole wide range of professions. It's just not simple. It can affect me if I got the DUI. I might have to be answering a complaint to the Board of Professional Responsibility. So these cases are important. And cutting corners does not make a difference. As far as the Schmerber case, that's just a red herring, Judge. As far as the exigent circumstances, if they were going to use exigent circumstances, they wouldn't have taken the time to go to the magistrate's office in Franklin at the sheriff's department, do the search warrant there, and then take her to the hospital in Franklin. It's just a red herring. As far as relying on other jurisdictions and federal courts, it's always been considered that the Tennessee Constitution gives more protections than the U.S. Constitution. And what more protection than our Constitution is general search warrants are prohibited. As far as Texas, well, Judge, I don't know about Greg Abbott, and I don't know if I want to live in Texas. You know, they kill people down there, so I don't really know if we want to adopt Texas laws as authority. So I've got some other things, but I'll leave my political comment to myself. But in this case, Judge, there is no prejudice to the state by just adopting the suppression. But it sets forth the clear and concise method of what should be done. Because I agree with my colleague, there is no authority about the search. But I believe it is a search. It is a separate search. You've got the seizure, and they seized it lawfully and legally. We're not complaining about that. But then, in the search warrant, it didn't authorize anything else. It just said to maintain it. Maintain as evidence, the property. They didn't say take it to wherever. They didn't say do anything else. They said that order was to maintain it. And if a search warrant is not like a court order, why are we doing it? Because orders are important. The orders are important. Because now, if we have that, do we need to follow an order? Because this order was, you should maintain it. And I know you don't like it, because I know you don't like it, but that's exactly what this case is about. Do we follow the law, or do we make an exception? And I'm asking the court to follow the law, uphold Judge Johnson, and suppress the blood. And like I said, they can still go forward. We just want our day in court. Thank you, Judge.
Thank you, Mr. McKinney. Mr. Groves.
Just a couple things, Your Honors. Regarding the reason we appealed this is before the court on a Rule 9 interlocutory appeal. We appealed based on the irreparable injury that the state would suffer on the DUI per se count. We certainly had enough evidence to continue with the prosecution on the DUI by impairment count based on the facts defense counsel mentioned, but we need the blood alcohol test results to convict Ms. Arora on the DUI per se count. As counsel also alluded to, there's a split of authority among the trial courts on this issue. We really need the court to resolve this. So that's why this case is before the court. We think that's proper. defendant hasn't argued in the brief that it should be dismissed or anything like that for those reasons. It's not a general warrant, Your Honors. A general warrant doesn't specify the person who is being searched or the items to be seized. This warrant particularly described the thing to be searched, Judge McMullen, as you mentioned, the blood. That's what was supposed to be searched. That was what was searched. And that's when the search ended. The defendant really doesn't engage with the state's argument at all regarding why, after the execution of that search warrant, do you have any privacy interest in the alcohol concentration of your blood. They simply don't engage with that critical issue. And Schmerber is highly relevant here. We're not arguing that the holding applies, that we're relying on the exigent circumstances exception. We're just illustrating that, you know, if exigent circumstances can justify blood alcohol testing, then certainly going further than that and obtaining a search warrant would extinguish your privacy interest and allow the blood alcohol testing after that. And if the case is really so easy as the defendant is making out, then they should be able to find at least one case from around the country that has interpreted the Fourth Amendment in this manner. But again, they haven't cited a single case that has come out the other way. And to the extent that my friend on the other side has referenced the Tennessee Constitution being broader than the federal Constitution, that wasn't raised in the briefs. They haven't made any argument that Article 1, Section 7 provides more protection in this regard. And in our opening brief, we cited a Tennessee Supreme Court case that says that the Fourth Amendment of the U.S. Constitution is identical in intent and purpose to Article 1, Section 7. So the Tennessee Supreme Court has, in fact, interpreted those two constitutional provisions to include identical protections. And that wasn't something that the defendant developed in the briefing. So we don't think the court should go down that rabbit hole. If there's no questions, we do respectfully ask the court to reverse the trial court suppression order.
Thank you, Mr. Groves.
Thank you.
The case will be taken under advisement. Madam Clerk? Yes, thank you so much. You good?
I'm good.
Call next case, please.
State of Tennessee versus Richard Falk.